And now I'm happy to introduce you to our next speaker. I already announced that we'll be talking about whistleblowing and privacy today, because when I talked to Frank before the conference, we were thinking about what other aspects of the data protection framework and the privacy developments should be taken more into account. And the whistleblowing part of it all is sometimes kind of yet too little discussed, basically. And I was very glad that Frank agreed to guide you through the key challenges and give some practical insights when a whistleblowing report actually pops up. So please welcome with me Dr. Frank Schemmel. He's the practice lead, international privacy and compliance of DataGuard. I think most of you know him already. He's been a regular guest at our Bitkom privacy conference, but also in our working group meetings. Frank, great to see you again, and I'll give you the floor.
Yeah, thank you, Rebecca, for the nice welcome, and also welcome you all to this session. And as Rebecca said, it's not about data transfers. You hear a lot, and you heard a lot already, and you will hear a lot about that and other initiatives. But as Rebecca said, whistleblowing is also an important and hot privacy topic. Why is that so? Well, maybe some of you know that there has been EU whistleblowing directive. It has been inactive, and it's into force for 3 years almost. And member states had until December last year to implement that, because directive, you need a national implementation law. And to date, only roughly about half of all the member states have introduced a new a national whistleblowing law. And among the countries that didn't do so is Germany. And funny enough, right today, in the Bundestag, in the German parliament, the proposed German law is currently discussed. So I will cover obviously all these things, but there might be some change. So please keep on track. And whistleblowing is not doable from a compliance perspective. The respective case management and then the internal investigation without data protection compliance. Why is that so? Obviously, from a data subject's view, I mean, it's often the case that special categories of personal data are processed, or other sensitive data. And there's also the issue and problem with, identity protection. So from a data subject's view, privacy is of the utmost interest. And on the other side, from a controller's view, they need to comply with privacy rules. In particular, if you talk to investigations expert, they tell you one of the biggest challenges we usually have during internal investigations are privacy related matters. Because if you want to do certain measures in order to gather evidence, for example, email screening or so, there's always a battle between gathering evidence and privacy. So taking privacy seriously from the very beginning is crucial in order for the evidence later to be lawfully used in court. So privacy is a very important part of any whistleblowing system. And today I want to cover the most important areas when a report pops in. I will not discuss about internal investigation. We can fill another session only talking about where privacy is related during internal investigations. But today we we want to talk about the earlier stage, right when a report is filed by a whistleblower. And you see the 4 main areas that are usually relevant in terms of privacy. And I will cover 3 today. What I will not talk about today is the responsibilities of processing. So who's the controller, who's the processor, because there's no rule of thumb. Obviously, if you use a software provider, a digital whistleblowing solution for your reporting channels, then you obviously need to take into account a controller processor relationship and agree on a processing agreement. But in particular, in complex group structures, you really need to have a look into that on an individual case-by-case basis. So this is something we cannot cover today. But what I want to talk about today is the legal basis of processing, retention and deletion, appearance, and of course, transparency and information obligations, because in particular for not hampering later investigation, it's very crucial to know when, to some extent, you can withhold and defer information, in particular to the accused and involved persons. But let us begin with the legal basis. And in the respective whistleblowing directive in Article 17, you find a respective paragraph, a respective section dealing with processing of personal data during the case management. And here you find the respective section in the German law, the so-called Hinweisgeberschutzgesetz, that hopefully will soon pass our parliament. And you can see you have a specific legal basis in the law for processing personal data, as long as this is necessary for performance of the duties of the reporting offices. And reporting offices means the office, the body that deals with the first report that pops in. So you have a whistleblowing system, maybe a whistleblowing hotline, or a kind of email system, and the reporting office is that office that deals with the very first reports that come in. And in order to fulfill their duties, they have to process personal data, and this is what the section is about. But it's not everything clear yet. If you take a look on my slide, I mean, it's the personal data is mentioned, but what about special categories of personal data? And if you look into the law, and also what the lawmakers have thought about it, you find no clue about that. Luckily, during discussion in our parliament, it was hinted that we should include in this section, obviously, not only personal data, but also special categories of personal data, to have a specific legal basis for this as well. Otherwise, we always have to debate, or there's an insecurity whether Article 9 GDPR applies or not. Another issue in practice will be, or could be, I mean, this section here talks about the reporting offices. Obviously, if you know and are familiar with internal investigations, after a plausibility check of the reports, and where you find certain reports as relevant, then you start internal investigations, and other departments, other internal departments, but also other external parties, for example, law firms or forensics experts, have to be included. And this section here, and it's the same with the very broad Article 17 in the Whistleblowing Directive, they don't talk about the receiving bodies. But obviously, if I have to transfer data there, they have to process them as well. And it would be good if there had been and if there will be included a specific clarification that this is also relevant for receiving bodies. So why is it so crucial to talk about legal basis of processing? You might think it is trivial, and yeah, to some extent it is, but you need to know what legal bases are applicable because of the records of processing activities, a DPIA that supervisory authorities usually deem necessary when you implement a whistleblowing system. And of course, your transparency and information obligations. You have to outline the legal basis as well. So you really should think about that. And the lucky thing is I just showed you the section, and in many other state laws and other European countries is the same. You have a specific legal basis in the law for processing, and the whistleblowing directive will be applicable for all entities with at least 50 employees. And if the whistleblowing directive, or the national law in this case, is applicable, then you can base the processing on Article 611C. So because there is a legal obligation, you have to implement a whistleblowing system and therefore also have to process personal data, and in conjunction with the respective national specific legal basis that has been enacted. If the whistleblowing directive or the whistleblowing law is not applicable, so usually where there are legal entities, companies concerned with less than 50 employees, then you have to base your processing usually on legitimate interest. I mean, in Germany and to some extent in other countries, you have specific legal basis for employment related matters. That's the section 26 of our Federal Data Protection Act here in Germany. But the scope is very narrow. And usually here in Germany, this would only be applicable if criminal offenses are concerned and have been committed during employment. Also, it could be the case that there are collective agreements in place, works agreements between the employer and the Works Council, for example, but that could not bind parties that are outside of the employer. And often the case, not only employees are concerned when you blow the whistle, but parties outside as well that are collaborating and are partners in crime, so to speak. And last but not least, there's always consent. But consent doesn't make sense to obtain consent because you cannot and you don't want to obtain consent from the accused person or other involved parties, because then you would tip them off. So yeah, I hope you got an overview about how or what legal basis in future will be applicable and why it's essential to know about your legal basis. And then let's talk and continue about the most difficult part, and usually also from a practical perspective, the most common issue when whistleblowing and privacy is concerned, and it's about the transparency and information obligations. So the compliance department or the legal department or whatever department is responsible for incoming reports, as I mentioned earlier, they have a vital interest to gather evidence, to get enough information to determine, okay, is this plausible or not? And if they consider it plausible, also to gather enough evidence for or during the internal investigation in order to stop those in infringements. And what compliance legal departments or whoever is doing the internal investigation don't want to have is that parties involved are tipped off, so they get information about the ongoing investigation and then could try to alter or get rid of evidence. So this is really crucial. But the GDPR applies. There's Article 12, 13, 14, and 15. So you cannot get rid of that. And usually it's very easy to inform the whistleblower himself. You have to do that, Article 13, at the time when personal data are obtained. And if you have a tool-based whistleblowing system, you would have a respective privacy notice on the landing page and would also include a link in the confirmation of receipt to the whistleblower. But obviously there is the accused and there are involved persons. And obviously you can, first of all, only inform them if they are identifiable and reachable. But then in general, Article 14 GDPR, you have to inform them no later than 1 month after receipt of the relevant information or at the time of the first communication with the accused or involved parties. And that's what the compliance department usually don't want to do, because it takes longer than a month to conduct these internal investigations. But deferral is possible under Article 14, para 5. But there in Germany, for example, there are also specific regulations in the Federal Data Protection Act. And the big issue so far was that a lot of commentators and particular data protection authorities, they considered these national German specific regulations as not compliant with EU law. The good thing about the new whistleblowing directive and the national law is that in the recitals of the EU whistleblowing directive, it's clearly stated that national regulations can provide exceptions for transparency and information obligations. And you can defer information as long as one of 3 reasons is applicable. First, a risk that the facts cannot or can no longer be clarified. That's the first one. The second one, assertion, exercise, or defense of civil claims would be impaired. And last but not least, preparation of criminal charges or criminal prosecution would be considerably impeded. And then you can withhold the information as long as the investigation is carried out. But after you conclude the investigation, obviously you have to inform the accused and the involved party, and that's usually done at the time of initiating labor law actions or filing criminal charges with the prosecuting officers. You find here on this on the slide case law, and it's really important because there's a lot of case law in Germany, and one of the court decisions said you need to do a balancing of interest tests whenever you decide whether to withhold information or not. So you cannot just say, oh, I just withhold it. You need to do an assessment, a balancing of interest test on a case-by-case basis. And there's also case law that in general, you don't have to disclose the identity of the whistleblower to the accused or to the other involved parties. Our Federal Court of Justice, the BGH, has decided earlier this year that this is the case. So that's about information obligations. Then shortly, before I come to an end, retention and deletion periods. That's also crucial. And in the German law, we have a specific regulation here in section 11, paragraph 5. It says the documentation is deleted 2 years after the conclusion of the procedure, which is quite interesting because so far, at least German regulators, German data protection authorities, they said you have to delete all the documentation and information 2 months after the conclusion of the procedure. So you see there's a big gap, and now compliance departments and legal departments, I think they are really happy because they have more time to retain the documentation. A big issue in practice is what the triggering event would be. It just says conclusion of the procedure. And even in the discussion in the parliament, they only found out 2 weeks ago, look, this might be something we need to give more guidance about. So I expect that in the final law that will be passed, at least in the materials explaining the law, there will be clearance of what triggering event is really the key event that you need to take into account when deciding when the 2 years start. Last but not least, there is also enforcement, and there's guidance by supervisory authorities. 2018, there's a really comprehensive paper issued by the gathering of the German data protection authorities, but you need to be careful because it's partly outdated. There is a very recent paper by the Baden-Württemberg supervisory authority from end of last year, which took the whistleblowing directive and the German law into account. And there is also a paper from the EDPS. It's also partly outdated, but the EDPS still refers to it. So whenever you deal with whistleblowing and privacy, look into these guidances. And there has already been enforcement. 2 cases in Italy where the controller and the processor meaning the provider of whistleblowing solutions of the software, have been fined because there were missing TOMs, insufficient TOMs, and a missing DPIA, and the fines were between 30,000 and 60,000 euros. So that's nothing you should take easily. And having said this, I hope you have now got better picture about what's essential during whistleblowing when a report pops in from a privacy perspective. If you have questions, I'm very happy to answer them afterwards. Just ping me. There will also be a webinar hosted by me and a leading whistleblowing solution provider next week, where we go into all the details and the new national law. So if you want to attend, just click on our partner page here in the Bitkom privacy swap card. And yeah, thanks for your attention, and looking forward to your questions afterwards.
Thank you so much, Frank. I see there is a question in the chat, but we ran out of time a bit. So maybe you can answer that in the chat, or
sure, will do.
The audience member. I do not see the name, but if you want to contact Frank directly, he's happy to answer. Okay, but for now, thank you, Frank, for introducing us to the privacy and data protection dimension of the new whistleblowing rules as well. I think it's a very important addition to our program today, and happy to talk about that again in the future.